Hi everybody, this is Professor Ostro. I created a reasonable suspicion and probable cause primer because after reviewing your discussion board assignments, I found that many of you still had some degree of confusion about the difference between reasonable suspicion and probable cause and what the police can do at one level as opposed to what they can do at another level. So I hope you find this helpful. Please go back and review the material from the past week before you prepare for the final, because there's going to be a lot of material in the final related to reasonable suspicion and probable cause, and I want to make sure that you fully understand it. Okay, so this is a reasonable suspicion and probable cause primer. Again, I hope you find it helpful. So what I'm going to do here is I'm going to review this idea of standards of proof. I think we need to get a little bit back into that so that you fully understand that. I'm going to also differentiate between reasonable suspicion and probable cause, and that's really important for you to understand those two differences. And then we're going to review those scenarios involving reasonable suspicion and probable cause that you were given as part of your discussion board assignment. And I want you to see and understand how I would go through them and compare that to how you went through them. And then you can think about, was there something that you could think about a little bit differently? Should you interpret reasonable suspicion differently? What could be done differently also? Okay, so let's get into it. So the first thing here is standard of proof. So standard of proof, again, think of it as legally sufficient evidence that is necessary for the government to act against a constitutionally protected person, place, or thing. What is protected by the Constitution? You are protected by the Constitution. Your property is protected by the Constitution. The vehicle that you drive is protected by the Constitution. Your home that you live in, right? Your computer, the information on your computer, the blood running through your veins. All of this is protected by the Constitution, the bag that you carry on your back. So a standard of proof is the necessary evidence that is needed by the government in order for them to do some sort of act against you, right? Some sort of legal justification, some sort of action against you. The highest standard of proof, in order to take away your freedom and sentence you to the criminal justice sanction, is what they consider proof beyond a reasonable doubt. Proof beyond a reasonable doubt is the amount of evidence that is needed to convict you of a crime. And that's more or less the highest standard in the law. So we can think of that as like the highest standard, the most certain. It's almost absolutely certain. It's almost absolutely certain that you are in fact guilty, legally guilty, right? Factually and legally guilty. So to convict for a crime, you need proof beyond a reasonable doubt. That's the highest standard. Now, well below that is what is known as probable cause. We can think of that as like a medium amount of legally sufficient evidence. We can think of probable cause in terms of probably. It's probably true that you committed this crime. It's probably true. It's not proof beyond a reasonable doubt. It's not absolutely certain, but it's probably true based off of the facts and the circumstances. So, probable cause is the amount of evidence that the government needs. In this particular situation, law enforcement agencies need to place you under arrest or to get a warrant against you. A search warrant for your home, for your person, an arrest warrant. So, probable cause. It's probably true. Think of it that way. That's like a medium amount of evidence, a medium standard of proof, right? Probable cause. And that's really not that much. Because if you think about what is probably means more than 50% chance, right? More than 50% chance, which could mean 51%. It could mean 60%. It could mean 80%, 90%. Probably means more than 50%. It's probably true based off of the facts and the circumstances. Less than probably is reasonable suspicion, right? That's like a moderate amount of evidence. This is something that may in fact be true, but it isn't necessarily true. It may in fact be false too. So based off the facts and circumstances, we think about this idea of reasonable suspicion, which is less than probable cause, right? This is the amount of evidence that the police need to forcibly stop somebody, to temporarily detain them, to question them, and to frisk them, okay, to frisk them. Now I'm going to also differentiate between a frisk and a search on the next slide, so that's really important, right? So the highest standard, proof beyond a reasonable doubt. A medium amount, or probably or more than probably, is probable cause. Less than that is reasonable suspicion, and the government can do different things at those different levels. So let's get into that. So the Fourth Amendment. The Fourth Amendment is where all of this law comes from, where all these rules and regulations come from. How the police act based off of facts and circumstances is dictated by the Fourth Amendment, by case law. So to understand that, you have to really understand the Fourth Amendment. And that's why I went over it in the lesson. So the right of the people to be secure in their persons, houses, papers, and effects, right? So that's basically everything against, this is a key word here, unreasonable searches and seizures. Unreasonable searches and seizures, right? Unreasonable. Remember, so if it's probably true that you committed a crime, is it reasonable to be seized? If it could be true that you were involved in a crime, is it reasonable that the police forcibly stop you and question you? Right? So what is reasonable and what is unreasonable? A lot of case law comes from that. Unreasonable searches and seizures shall not be violated. No warrant shall issue, but upon probable cause. Probable cause, remember? Probable cause, facts and circumstances that would lead a reasonable person to believe that a crime was committed and a certain person committed it. Okay? So facts and circumstances determine the appropriate standard of proof. Right? And what are facts and circumstances? Facts and circumstances of a crime or an event are what give the police and the government a specific standard of proof. And this can come from a victim statement. Does the victim make a statement to the police in person? Do they call over the phone? Right? Are they reporting it on behalf of somebody else? What the victim, right? That plays. Is the victim intoxicated? Is the victim having a mental health crisis? Did the victim come running up and has this evidence that the victim was just victimized? There's injuries and blood and scratches. Okay, so the victim. Witnesses. What do witnesses say? What did witnesses observe? Time and location. So if the victims give information about, I was just the victim of a crime 5 minutes ago. Okay, right. So that's different than 5 hours ago or 5 days ago. Right. The immediacy of something also figures into what standard of proof. Something happens 5 minutes ago. Is it reasonable that the person might still be in the area? If it happened 5 days ago, is it reasonable that the person might still be in the area? Right? So these are facts and circumstances that lead police and the government to make decisions about what standard of proof. Location. So if somebody's victimized 5 minutes ago, is it reasonable for the police to search 20 miles away? Can you travel 20 miles in 5 minutes? Probably not, unless you are in a helicopter or an airplane. Right? So are you speeding at very fast speeds? So it's just not reasonable. Okay? So we have to think about time and location. All of these matter. If somebody was the victim of a crime, it happened 5 minutes ago, and the police search within a 10-block radius, is that reasonable? Well, that's probably reasonable because somebody could travel 10 blocks within 5 minutes. It's reasonable. If you said 100 blocks, well, maybe that's not reasonable in 5 minutes. Okay, so accuracy and detailed description of the alleged perpetrator, too. So when the victim gives information about who victimized them, that's also important. What they were wearing, what they looked like, their race, their ethnicity, their background, their height, their gender. All of those things, not any one thing in and of itself, but all those things together figure into reasonable suspicion, probable cause. Also, police training and experience, that matters as well. And you see that coming from the Terry v. Ohio example, which is the Terry v. Ohio case, which sets the standard for reasonable suspicion and stop, question, frisk. So the detective in that case had many decades of experience, and the Supreme Court took that into consideration. Police training and experience. Right? And then other evidence, video, observations, calls for help. If you hear somebody screaming, oh, that guy just robbed me, or he just took my pocketbook, or this or that, help me. Right? So that figures into the immediacy of facts and circumstances. So all of these together, who is the victim? What is the victim's status? Witnesses, time, location, accuracy, training, experience, and any other evidence. All of that figures into reasonable suspicion, probable cause, standards of proof. Okay. All right, so I want to look at reasonable, probable really quick. Reasonable suspicion, if we look at it, reasonable suspicion, again, is lower than probable cause. And it could be true, but it may also be false. Right? It could be true, but it may also be false. It's less than probable cause, because if you have probable cause, then the person would be under arrest. Right? This is the necessary amount of evidence that the police need to investigate further. And at this level of standard proof, though, they are constitutionally authorized to forcibly stop somebody, even at gunpoint. If it's a violent crime or there's a weapon involved, they can forcibly stop people at gunpoint. Tell them to get on the ground, put your hands behind your back, temporarily detain them and question them. They can do that under reasonable suspicion when the facts and the circumstances support that. Violent crime, weapon, okay? They can temporarily detain and question temporarily detain and question. It's not interrogative necessarily for Miranda. It's not custody plus interrogation, but it's a temporary detaining. Right? The courts have determined that the police can question individuals under reasonable suspicion. They can frisk the outermost garment. Frisk the outermost garment. That means if they reasonably suspect that the individual is carrying a weapon, they can frisk in the area where that weapon might be. So if the police temporarily stop somebody because they believe, they reasonably suspect that an individual just committed a violent crime, maybe a robbery, gunpoint robbery, and they see a suspicious bulge in that person's waistband, they can frisk that person for that in the waistband area for that weapon. Now, for violent crimes, it's frisk outermost garment, right? For other crimes, it might be crimes involving other types of weapons. It might be, a reasonable suspicion frisk based off of just the outermost garment. All right, and then this can become probable cause. Reasonable suspicion can turn into probable cause, right? So you have reasonable, and then you stop somebody that you reasonably suspect just was involved in a crime, and then you develop probable cause out of that based off of their answers, based off of witness statements, based off of something that you frisked them for. That happens frequently. Different from that is probable cause. Probable cause is it's probably true that a crime or an offense was committed. It's probably factually true. Right? And this is where people get into a little bit of confusion about the role of law enforcement in our criminal justice system. People will say things like, well, the police can't prove anything, or the police don't have any proof. The police don't need proof. The police need probable. The prosecutor and the courts determine proof beyond a reasonable doubt. The guilt or innocence, legal guilt, legal innocence. Right? So the police are interested in probable, and that's a much lower threshold than proof. Okay? So people think police can't prove anything. Well, the truth is they don't actually need to prove anything. They just need probable, which is much lower. Courts, prosecutor, are the ones that determine proof. So it's more than reasonable, and at this level of proof, this standard of proof, the police are constitutionally authorized to arrest, to use necessary and appropriate force, which even can mean deadly physical force if necessary. Deadly physical force. They can use necessary and appropriate force to effect an arrest here at probable cause. All right, so they can search inside of pockets and belongings. They could also obtain a warrant. So a search is inside of pockets and their belongings. Frisk is outermost garment. That's the difference. They also is the necessary standard proof to obtain a warrant. Okay. So now let's take a look at those two scenarios. I'm just going to move my picture down here a little bit so we can see a little more clearly. Three male teenagers are hanging out in front of a small family-owned grocery store, acting rowdy, making comments to people who are passing by. Okay, not an uncommon thing if you live in a big city, right? Teenagers, that's what they do. They hang out. Right? Sometimes they act rowdy sometimes, right? As a result, people are avoiding that side of the street. So it's a disorderly conduct type of situation, and they're avoiding the street in the grocery store. The manager of the store asks the three teenagers to please move along. The teenagers say, "Go F yourself, old man." I always find it interesting when people say, "Well, the cops can just tell them to move," or somebody doesn't mean they're going to listen, So that's something that police often have to deal with. The manager calls 911 knowing that a call for a disorderly group will take a long time for the police to respond, especially in places that have a lot of activity. He says the teenagers are selling drugs and have a gun. We don't know if that's true or not, but he says it. So the police arrive with lights and sirens. They approach the kids, firearms drawn. All right, so this is a lot going on. This is not really an uncommon type of scenario. And something to think about is what is the information that the police are getting? So the only information that the police have is what is being given to them by the caller. And what police officers will typically do, and police departments typically do, whenever you have these kind of like potentially volatile and dangerous situations, is the officers might say, Central, the dispatch, can you tell me if there are any other phone calls coming from this area? Are there any witnesses? Can you call the person back on the phone? They'll try and get the person back on the line. Say, what are you seeing? So cops would, good police work would dictate that you have to do some kind of follow-up before you get there, right? All right, because you don't know anything, and all you know is, there's kids hanging out in front of this place, and they're selling drugs and they have a gun. So somebody says. Now, also, what I want to point out is, for veteran police officers who work a steady patrol or steady beat, they may know this corner very, very well. They may know this intersection very well, and it could very well be that the police have had a history of issues in that particular corner, and that might change standard of proof. So you see, facts and circumstances are very important. All right, so my first question is, what standard of proof do you believe the police had during the scenario and why? I would say that this is it is reasonable. It is reasonable that this is true. Why is it reasonable? It's reasonable because you have a victim or a complainant. The person identified themselves over the phone, and they gave pretty detailed information. Is it probably true? Well, we're not there yet, but it's reasonably true that they're selling drugs and they have a gun. It's reasonable. It doesn't have to be correct. Remember, reasonable is less than probable. It just needs to be reasonable. And I would say, if I'm a veteran officer and I know this neighborhood and I know this community and I know this street corner, and I get a call like that, it's reasonable that there's a crime going on. It's not necessarily probable, but it's reasonable. So now, how I approach that might be very, very different. Right? Did the standard of proof the police have in the scenario change at all? When and why? And I'm going to come back to that in a minute. What should the police have done in this scenario? Well, that's a very difficult question because it depends on who you ask. I would say, depending on the facts and circumstances, it could be appropriate to maybe for the police to pull up without lights and sirens, kind of eyeball what's going on, talk to the store manager. That could be appropriate. Could be appropriate. You know, if I'm a veteran officer and I know the corner and I know the kids, I know the store owner, right? And I don't have any other calls. Could it also be appropriate and reasonable for me to pull up? Let's say I don't know the corner. I'm assigned to this patrol sector for the first time ever. For me to show up, pull my firearm out, and say, kids, turn around, put your hands behind your back. I mean, it could be reasonable to do that as well under the facts and circumstances. Could be reasonable, right? And they're frisking for a weapon. So, what should they do is really a tactical question. It's really more than it is a legal question. So question number 4 is the legal question, which is what could they have legally done in the scenario? What could they have legally done in the scenario? Well, if they have reasonable suspicion, the police legally can forcibly stop, temporarily detain, question, and frisk their animal's garment. They could. Now, should they? That's a different question. And that's based off of police training, experience, facts and circumstances, familiarity, witness statements, and all those other things that go into it. So going back to number 2, did the standard of proof the police have in the scenario change at all? I would say at no point did the standard of proof change. All right, here I think the minute the person made that phone call, he identifies himself. I'm the owner of a grocery store. There's kids hanging out. I believe that they're selling guns and they have they're selling drugs and have a gun. That's reasonable based off of those facts and circumstances. Now, this guy gets on the phone and he just says, there's kids selling drugs and they have a gun and here they are, click. Well, that might not be reasonable yet. That might not be reasonable yet. But you might be thinking, well, what, the person's lying. Is he lying? Is he telling the truth? He's not telling the truth. Well, the police don't know that yet. That's what they have to do is conduct an investigation. And the truth of the matter is that police get very limited amounts of information. And they have to base their reasonable suspicion, probable cause, often off of very limited and often incorrect information. So all of this figures into standards of proof. Okay? It's not an easy scenario, and it wasn't meant to be. The next one is scenario number 2, which is also unfortunately very common all too common in big cities throughout the United States. Woman is walking home from work. It's dark and few people are around. She's accosted, grabbed from behind. Person displays a knife and says, "Give me your pocketbook." So she does what she's told. Right? The man runs towards the subway before she gets a good look at him. She just gets a fairly detailed description: dark-skinned male, 6 feet tall, black hoodie, dark jeans. And you might think that's so vague, but when somebody who is the victim of a crime like that, that's actually a pretty good. That's actually a pretty good description. She thinks he's in his late teens. She calls 911 and gives the above description. Many people might be like, I don't know. There's just some guy ran over to me. He was wearing a hoodie, and I saw a knife, and I don't. It just happened so fast. I was scared, and so that's not. This is very good. The police arrive in the area. It's 5 minutes later. Remember, that's important. Time, distance, location. They go into a nearby subway. Right, they're doing a canvass. They're searching for. A woman says, "I was just robbed. Help me. This is what the guy looked like. He took my pocketbook. He pulled a knife on me. I'm afraid. Police, help me." They see somebody that fits the description. And in big cities like New York, right? Many people fit this description, especially in subways where they're so crowded. They stop. Can they stop that person at forcibly? Absolutely. And they frisk him, at gunpoint. Could they do that? Absolutely. They sure can. It's a reasonable, and victim of a crime, location, distance, description. Put all those things together. It's perfectly reasonable. Person has a knife. It's a violent crime. Perfectly reasonable for the police to show their firearm, threaten deadly physical force. The female victim, they do what's called a show up. They bring the victim to the perpetrator, right? The victim goes to the perpetrator, and then she looks at the guy and says, "That's not the guy," right? And this is after the police find an illegal firearm on him. Now, this is like throws a big monkey wrench into this scenario, right? So my question is, what standard of proof do you believe the police had during the scenario? Why? Well, they had reasonable suspicion, no question about it. The police respond to an emergency 911 call. They have a victim. The victim is reporting directly to them, giving them information. It happened within 5 minutes. They do a canvass of the area within the immediate area. It's perfectly reasonable that somebody would commit a robbery and then run a couple of blocks into the subway. Perfectly reasonable. It's not like it's 20 miles away. It's within a block or two. 5 minutes in the past, perfectly reasonable. And then a reasonable suspicion. Can the police pull out a firearm, forcibly stop? Yes, they can. Absolutely. That's what the U.S. Supreme Court has said that over and over again. Okay, so then they reasonably suspect that he's this guy is the perpetrator. They frisk him. They don't find a knife. Remember, the woman said she was threatened with a knife. They find a firearm, and it's a legally possessed firearm. Wow. All right. So what do you got here? And but she says that's not the guy. So they have reasonable suspicion. When she says that's not the guy, they lose reasonable suspicion. But because he's carrying an illegal firearm, then that becomes probable cause for a different crime. Okay. And some people might say, well, the initial stop was illegal because that wasn't the guy. Well, no, it wasn't. You can have reasonable suspicion and you can lose reasonable suspicion. And some people will say, well, doesn't the exclusionary rule kick in? The police were acting in good faith when they stopped him, when they questioned him, when they frisked him. And they weren't searching him. They were conducting a frisk under, the Terry v. Ohio case law. So what standard of proof did the police have? They had reasonable suspicion. They lost their reasonable suspicion, but they gained probable cause off of something else. So what should the police have done in this scenario? I think I've explained that already. This is a forcible stop, in all likelihood at gunpoint. Right. So I think again that's more of a tactical question, but I think most police officers, most police departments would encourage a very strong response if you come in contact with somebody who just committed a robbery with a weapon. Okay, but again, that's a more tactical question. What could they have legally done in this scenario? Well, they did exactly what they could have legally done. Forcible stop, question, detain, and frisk. Okay. All right. So I hope that these kind of scenarios, going over this with you, helped you, and hopefully clarified some of your some of the issues that you may have had when you went over the scenario. And some of you might look at this and be like, I don't agree. And I know that a lot of you don't agree because I read your assignments. But what should and shouldn't be done is different from what can legally be done. All right. So when you think about your answers, I want you to consider: are you answering this? Do you disagree because you don't believe the law, or you disagree because you don't believe in the tactics? Those are two different issues. All right. I hope this was helpful. Good luck on with the rest of the course. We only have another week to go. And good luck on this. Hopefully, this will help you with the final. Okay, that's about it. Have a nice day, everybody.